Are you thinking about a shortcut to keep your house out of probate? The Ladybird deed might sound perfect until it isn't. Let's talk about why it can both be a blessing and a headache. Welcome to the Death Readiness Podcast. This is not your dad's estate planning podcast. I'm Jill Mastriani, former estate attorney, current realist, and your guide through wills, trusts, probate, and the conversations no one wants to have. If your Google search history includes, "Do I need a trust? What exactly is probate? And am I supposed to do something with mom's will?" You're in the right place. When I was a brand new lawyer working out of a basement office, I received a call from someone asking if I could draft a Ladybird deed. And I thought, Ladybird Johnson? What does she have to do with deeds? If you've ever been new at a job, you know that feeling. Questions coming at you that you have no idea how to answer. For me, Google became a lifeline. This was 2012, and I felt a lot like Isla Fisher in Confessions of a Shopaholic. There's this scene where she's sitting at her desk as a journalist for a financial magazine, completely out of her depth, and types into Google, "What is finance?" That was me, except I was Googling, "What is a Ladybird deed?" But before we get to Ladybird deeds, I want to take a step back and define what a deed is, generally. A deed is the legal document that proves who owns a piece of real estate and transfers that real estate when ownership changes hands. The seller, called the grantor, signs it. Once it's recorded with the county where the real estate is located, it's official and part of the public record. So what about the Ladybird part? Another term for a Ladybird deed is a transfer on death deed, a way to pass real estate directly to someone after you die, without probate. And it turns out that a Ladybird deed has nothing to do with Ladybird Johnson. The name came from a Florida attorney who used a fictional character named Ladybird in his training materials to describe this particular type of deed, and somehow the name stuck. Tennessee, where I practiced, doesn't allow Ladybird deeds. But I've always been curious how they work in states that do. And when I received a question from a listener named Olivia asking about them, I knew it was time to talk about them on the podcast. I invited Minnesota attorney Jen Gumbel to join me today. She's going to share her firsthand experience with Ladybird deeds, what she's seen go wrong, and how Minnesota's legislature has responded. Hi, Jen. Thanks so much for joining me today.
Happy to join you.
Today, we're going to talk about transfer on death deeds. I, as a former practicing attorney in the state of Tennessee, where we do not have transfer on death deeds, I have never drafted one. I've never dealt with one. I've never seen the good, the bad, and the ugly to come of them. But there are listeners who have asked me about them and whether they're a good idea. Sort of along the same lines of DIY or do-it-yourself wills or using internet forms for your estate plan. And of course, we've seen bad things come of that, but they are really enticing because they're cheap and you think you can do it yourself. In Minnesota, where you practice, the statute has a form in there that you can use, that you can fill out yourself. And so you see that and you think, what could possibly go wrong here?
That's so many things.
So you're saying that like DIY wills, perhaps the transfer on death deed is not the panacea that we'd like to think it is.
Right. If you take the easy way out, you are probably going to make things more difficult. But if you are willing to put the time and effort to do things right, then you make things easy for people.
So in your position as a practicing attorney, they can pay you now, or their family can pay you maybe 10 times that later. That seems to be the option a lot of the time.
It really can be. And specifically with these transfer on death deeds, like you said, the statute lays out a form. And real estate deeds in particular are very technical documents.
They are, yes.
And so you can have the form, but do you know how to describe your property correctly so it transfers what it's supposed to? Oftentimes people will look at, like, our tax statement will have essentially a quick and dirty legal description, but oftentimes it's not the full legal description that it should have on a deed. People use that, they bring it to the recorder's office, and the recorder's office is like, we can't take this.
Okay.
or you didn't get the right part notarized. Like it's a really technical document. And so even when you have the form, you still might not fill it out the right way.
Let's say you got the form, right?
Yeah.
And you fill it out and you're trying to do it the right way. What do you need to do right?
Well, you need to have the right people sign it.
And who might that be?
In my state of Minnesota, spouses have to sign off. And that's something that we see too often is people don't know that and they don't expect it. Well, I'm the only one on title. It was my family's property. And they expect that for whatever reason, their spouse doesn't need to be a part of it. And it might get accepted. We get a lot of people who say, I went to the recorder's office with a form and a question, and they say, we don't give legal advice because that's what it is.
Yeah, they don't. And they shouldn't.
Right. And so they just say yes or no. We can take this or no. And sometimes they take it and it still doesn't work, because that's not their job. Their job doesn't meet the requirements that the law says we need to record it, but is it actually doing what you want it to do? That's not their job.
So if you go and get your transfer on death deed recorded, that doesn't mean that you did it properly and it's going to work.
No, it doesn't mean that it's doing what you want it to do.
Okay. One of the reasons people are using transfer on death deeds is to avoid probate. So let's say you're in a situation where the property owner is incapacitated, but they have a power of attorney. Let's say it's a general durable power of attorney in place with a named agent. Is this something that an agent could do? Could they execute a transfer on death deed?
It depends on the agent's powers in whatever document gave them that power. But oftentimes when we run into it, they do have that power.
So the power that you'd be looking for is it the power to execute deeds?
Yeah, to transfer real estate.
Okay. So let's say that you have the best intentions, right? And you're bent on you're not going to go to an estate planning attorney to do this. Let's say that you name your daughter as your beneficiary. What happens if she predeceases you?
Oh my gosh. It's that lawyer answer of it depends. It depends on what that deed says. And this is something that I think, kind of to back up for a second, like transfer on death deeds are a great idea. And Minnesota adopted them. I think the first state that I'm aware of that came up with it, I think was Florida, and traditionally called Ladybird deeds, And really the thought process was, well, if a bank will let you list a pay on death beneficiary, if your retirement account lets you list a beneficiary, life insurance lets you list a name who can receive something, why shouldn't we be able to do that with real estate? And Minnesota goes even the next step, and I think was the first in the nation with this idea. Why can't we also do that with vehicles and boats? I think it was the boats really for us.
Yeah.
Lake culture. But just this notion of if you know who you want to have this, let's say that. Because the fundamental thing, and I think this is where people start to think, well, is there an easier way?
Easier or cheaper way?
Easier or cheaper way. Not enough people do wills. Wills have a specific function. It's a super important function where when people don't do it, I see things go off the rails all the time.
Well, what is the function of the will?
The function of a will is to say, well, if it doesn't have a beneficiary designation, if this asset doesn't have a direction of where it's supposed to go next, then here's where it's supposed to go. The problem is that it's for probate, because if the will only tells us what happens to the things that don't know where it's going, probate court happens because there's enough that doesn't know where to go, enough things that are stuck and left in that person's name, and it doesn't have a direction on it. That's what determines whether or not you have probate.
So just to make sure that we understand. So if you have an asset that has a beneficiary designation, like life insurance or a retirement account, and let's say, for sake of argument, that the beneficiary survives you, then those assets are going to avoid probate.
Go directly to that person. On your death, they are the owner. Bam. No rules.
But if you have an asset such as a bank account, perhaps a house titled in your individual name without any sort of designation, then those assets are going to go through probate.
Yeah. So those assets, and importantly, each state will have like their level where they say, if this much is stuck in someone's name, the court has to be involved in that process. And if it's less than that, there's something commonly called small estate affidavits, right?
If what would be sort of administered pursuant to your will in probate the value is less than a certain amount of money, you might call that a small estate.
Yep. And I think many states are like this, but to reference back to my state, Minnesota also says, or any real estate in any value.
So you cannot do a small estate if you have real estate in Minnesota.
That is stuck in your name, that it doesn't know where to go.
Okay. So let's say we don't have real estate, just to take that to its end.
Yep.
What would be a small estate in Minnesota?
In my state, the value is total value less than $75,000.
Do you not need to go to court?
Right.
Okay.
You are able to have authority to gather those assets and collect those assets by using the affidavit that says, I'm under this amount, I qualify as a small estate.
And then you might just take that affidavit, say if there is a bank account, to the bank. And in Minnesota, they allow you to do that.
Yeah.
Okay. So let's get back to the transfer on death deed, which if it's done properly, it can avoid probate.
Yep.
And you did just say, and I want to make sure that we all heard that you did say that a transfer on death deed is a good tool.
Yes.
Now, like any tool, it needs to be used properly and by someone who knows how to use it.
Exactly.
So let's go back to the example of a father executing a transfer on death deed in favor of his daughter. So his daughter is to get it when he dies, but she predeceases him. She dies before he does.
Yeah.
Under Minnesota law, and this is going to be state specific, if she has children, the real estate would go to them. But if she didn't have children, the real estate would pass as a probate asset and be distributed pursuant to the father's will. So that's if you have one named beneficiary as your recipient. Let's say that you are going to leave the property to 3 people as joint tenants, meaning that they own it together. What happens if one of those people you've named as a joint tenant dies before you do? 2 of them survive you, but one of them dies. What happens?
Well, just with the joint tenancy rules, it's survivor wins. And oftentimes people don't intend that, like they send it down to their kids and they don't understand what the jargon is. So maybe they see that term somewhere and think, gosh, I better throw that on my deed because I don't know what it means and it probably is important. So I better put it on there.
Sounds good. Joint tenants.
Right. And what happens typically on typical deeds is survivor gets it. And then there's been like some attempt under our transfer on deed statute to try to fix that scenario. And that also comes out in very not intended, consequences. There just isn't a one size fits all way to resolve. Like, I want to give it to my 3 kids and I don't want to go to the trouble of laying out exactly what I want to have happen, in different scenarios, put some good rules in place.
And for property, you want some rules generally
Yes.
if you have a bunch of people owning it.
Yes.
So if dad thinks he's going to leave his vacation property to his 3 children without any rules, and perhaps we have a problem on our hands because
Yes.
with real property comes expenses.
Right. Exactly. I mean, we see that scenario with cabins a lot. This is something that has expenses and it doesn't generate income.
Right.
So what happens if someone can't contribute to the expenses or doesn't use it? So they don't want to contribute to the expenses. And a bigger problem on an asset that creates income, but people can have different ideas of what should happen. And so they should be given rules, is farmland. If we have one of the siblings who is farming it and we have the other ones that aren't, and we have farm prices going like this, but commodity prices going,
Let's
prices
use
are going
words because
up.
we're not watching it in video.
Right.
So
Property
let's
prices,
say that-
I'm not being a great guest right now. Property prices are increasing,
Okay.
but maybe, so like the quote unquote, the fair market value of this land is higher and going up,
Okay.
but the economics of the farm may be commodity prices. What is the price of corn? What is the price of wheat? What is the price of cattle, right? When you sell it. If that's going down, then what is that going to do to the farm? Well, the non-farming owners of that land might not understand
The
that.
siblings, perhaps, right? In our scenario.
Yeah. And so things get totally out of whack because someone looked at it and they said, great, I don't have to put any rules out there. And what I'm really dancing around at, right? We keep talking about rules and we're kind of dancing around kind of the elephant in the room of a trust. What's a trust? Why do people do trust? Well, it's to create rules that isn't through the court system.
So when you're talking about rules, tell me a few rules. Now,
Yeah.
of course, they wouldn't be sort of fleshed out the way you would in
Yeah.
a trust agreement, but what are a few rules you might have?
Things like a cabin where you say, all right, if someone can't contribute, here's what's going to happen to their interest.
Can't contribute cash to pay expenses.
Right, exactly. here's some rules about if someone wants to buy everybody else out. How are we going to set that price? Do they need an appraisal? Can they use what the county is valuing? What happens if two people want to buy it? How do you determine who's going to be the buyer? With farms, are we going to let the farmer rent? Are we going to let them rent at a discount? Are we going to base that on fair market land prices or what the commodity prices say?
Do you mean rent from the other sibling owners?
Yeah. Well, and in a trust, they don't have to rent from the other siblings.
Oh, it'd be from the trustee.
Because if one of those siblings die, well, you got to sign a rental agreement with somebody who can speak on behalf of real estate owned by someone who's dead. They now have a probate, right? Whereas if you give rules to the scenario, if you put it in a trust and your trust has rules, it's always that trustee, right? And so here are the terms that the farming heir can rent from the trustee. Something happens to that trustee. We know who the next one up is. We know how to figure out who the next one up is. And so they're just dealing with that one person. Deaths don't kind of matter anymore because you're given rules to it. And then it makes it very clear to say, yes, and then you guys who are going to receive the benefits of this income, this is how rent's going to be determined. We're not looking to you to decide what you think is fair.
The rules, we're looking to the rules in the trust agreement.
We're looking to the rules that we're given. Yeah.
So for a trust, you could put real property in a trust during your lifetime.
Yep.
You could make that transfer into a trust, and then the real property would not be part of your probate estate. It would not go through probate.
Right. Because it's not in dead person's name. It's in a trust.
Let's say you didn't want to put it in trust during your lifetime.
Mm-hmm.
Could you name the trust as the beneficiary of a transfer on death deed?
Yes. And that is a very common technique. It's something that, as an estate planner, it's kind of like the best of both worlds. There can be difficulties with transferring real estate. And a lot of it has to do with a mortgage. Most people during their lifetimes are going to have a mortgage on their home, and they might not outlast their mortgage. They might die while the mortgage is still out there. And most mortgages will say, if you transfer this, we can call the note due.
When you say you can call the note, what do you mean by that?
It means that they can say, terms of the mortgage are over. You owe us X amount of dollars still, and we want it now.
So pay up the entire mortgage that's due, not just your monthly payment,
Yeah.
And pay it now. And you're saying that could happen sometimes if you're trying to transfer ownership of real property during your lifetime.
Right. And so with having a trust as part of your estate plan and a desire to avoid probate, you got to get that real estate to get to that trust at your death, right? If your only option is to put it in the trust, if you have a mortgage that says you have to ask for permission before you transfer it out of your name, not all banks are responsive. Not all banks understand. So that can be difficult to do. And not all banks are going to foreclose on that kind of scenario. Not all banks do, but they could. And that risk is a pretty big risk to take. So that's been the rub. That's been the problem of how can we minimize the need for probate? But some people can't put their real estate in a trust now.
So what's the solution?
You can use transfer on death deeds in conjunction with trust, where you say, I have rules, but this transfer won't happen until I die. So I'm not in violation of my mortgage.
So instead of naming, say, your 3 kids or your daughter as the beneficiary, you are naming the trustee of that trust as the transfer on death beneficiary. And if that trustee predeceases you, well, there's going to be another trustee who's going to take over. So the death of an individual person is not going to be a problem because you're actually transferring it to an entity.
Yeah. And your beneficiary, if they pass away, you can say what happens next. It does go to their spouse. That's fine. Or no, it's only going to go to my grandkids.
Mm-hmm.
And then the trustee will, let's say those kids are little, under 18. Okay, well, this trustee can manage it for them, sell the property, do whatever.
Or in the case of, let's say, the farm property where you're going to have the 3 siblings sort of as beneficial owners under the trust, but the trustee is making sure that all the rules are followed. So the property still remains titled in the name of the trust, and the trustee is still in charge of the property, but the siblings are perhaps beneficiaries of the trust.
Mm-hmm.
Okay. What about the other big issue that people face, which is everyone's worried about Medicaid and whether they're going to get a Medicaid lien on their real property if they ever end up in a nursing home?
How can I have the nursing home not take my house?
How can you avoid that? And I'm going to link in the show notes to an episode about Medicaid and whether or not they can take your house in case anybody wants to look at that. But if I live in Minnesota and I execute a transfer on death deed to my daughter, let's say, can I avoid a Medicaid lien?
The clear answer is you cannot avoid a medical assistance lien through the use of a transfer on death deed because Minnesota made sure of that. And here's how. So this automatic transfer at death, it works really great, but the state of Minnesota wanted to make sure. And the thing to understand about medical assistance is, number one, when you're saying, I don't want to use my house to pay for nursing home care, then the only alternative that you're talking about, unless you have other assets, long-term care insurance, you've made other plans. And if you have not done that, then your option is asking the taxpayers to pay for it. That's the reality.
Right.
That's what medical assistance is. And Minnesota, when they set up these transfer on death deeds, they said, we want to avoid probates. What we don't want to avoid is the ability to get the taxpayer reimbursed for paying for someone's nursing home care. And so when they created the statute, they said, well, on a transfer on death deed, so on these different real estate interests, when someone passes away, the transfer because of a death links back to that original deed, and you file a document that says, yes, here's the death certificate, they died. Here's that deed that says I get it because they died. And when you do that on a transfer on death deed, the way our statutes are set up, it says you cannot record it unless you have a certificate from the state of Minnesota that says there's no money owed.
Okay, so the state of Minnesota is going to catch you when you try to record your property interest, your ownership, because they're going to require.
Yep, you have to go through the state to get your ownership interest.
So in order to actually record, you're going to have to pay what's owed.
You don't necessarily have to pay what's owed. You just get it subject to that medical assistance lien, and you can't sell it without getting that lien paid off.
Okay. So the next thing I want to talk about is insurance, homeowners insurance, and how that all works. Because
this is brand new in our state.
Yeah. So what happens if dad wants to give the house to his daughter and he dies? Daughter survives him. So far, it's working pretty well. A couple days after dad dies, the house burns down.
Yes.
Is the daughter going to be able to recover insurance proceeds on that?
So this sounds like a crazy what if, right? If you're listening to this, you're like, what? Like, how would that ever happen? Like, that's no. And it happened in Minnesota. And so it brought up this question of what's the duty of the property insurance to the new owner?
Well, before we get into the duty, let's just say the interesting part is it didn't just burn down, somebody burned it down.
Yeah.
And it was the ex-wife of the man who died who burned it down. So, okay, now let's continue with what the duties are.
Right. The case is even more dramatic. The question it brought up was, well, okay, it transfers automatically at death to the new person, to the daughter.
Okay, so she owned it. So at death, she owned it. And so we were just talking about recording it after death. So you're saying she actually owned it even before she goes and tries to get it recorded.
Because if we have a gap, the only thing that can bridge that gap is dad's estate. And the whole point of these deeds are to avoid the estate. And so the statute says, well, you got to have the recipient daughter's interest come, we say vest is the term, but daughter's interest has to come. There can be no gap. It comes up when he dies. It's there when he dies. It's just a matter of showing it in the records.
So at the moment he dies, this transfer on death deed says the property belongs to the daughter. There's no gap. Okay.
Right. Yep. That had a consequence with insurance because the insurance company said, we didn't insure her. We insured him.
Okay.
We don't have a contract with her. And so we don't need to pay anything out. Now, this doesn't come up with probate, interestingly enough.
Why not?
Because of that gap.
So who fills the gap in probate?
His dad's estate.
Okay. So if he had not named a beneficiary, if he had not done a transfer on death deed, and at the moment of his death, his estate sort of becomes the owner.
The insurance probably would have honored that.
Okay.
To the estate of, to the estate of their client.
But here we had no estate.
Yeah.
We had no estate. It just went invested directly. Well, in this particular case, it was the decedent's niece, but it vested immediately in her.
Yep.
The ex-wife burned the house down.
Yep. It was not insured.
It was not insured because the niece did not have insurance on the house. She would have had to go out and get an insurance policy.
And honestly, probably not the niece's fault at all,
No,
because it takes a while to become aware of these things,
exactly. Yeah.
and to get your head above water after a death, and to start to ask questions and know who to talk to and start to look into those things.
So what did Minnesota do? Did they think that that was a good result, or are they trying to do something about it?
No. um, so they changed their statute to require insurers to provide 30 days notice, which from my perspective in dealing with this every day, I find that amount of time
It's
little
short, isn't it?
laughable. A month after a death, people are just wrapping up the funeral.
Right.
I don't know how aware they are of being a recipient of a transfer on death deed somewhere in the state, So I don't love that time frame. I don't know how beneficial that time frame is.
But is that not automatic?
It's not automatic.
Doesn't the person transferring the property needs to notify the insurance company?
They need to proactively, before their death, tell their insurance, agent, or there's a process and exact information you have to give them to the right people, but you have to tell the insurance company, I've done this transfer on death. By the way, this property has a transfer on death deed on it. And then you get that extra 30 days.
You can't just assume that if you're the recipient of property via a transfer on death deed, that you are going to have that 30-day period where you have insurance coverage. Because first of all, you don't really know if the decedent had insurance coverage.
Right. Yeah.
So it's still something that you would need to look at. Now, what if someone is listening to you and thinking, oh, crap, I did a transfer on death deed and I know I didn't do it right and I'm just going to cause a big mess. Can you undo it?
You can. At least in our state, it's very easy to. They created the statute. I tell people, like, the glory and the rub of the state of Minnesota is they think through their laws.
Okay.
So Minnesota allows for revocation, and you don't need to notify anybody other than recording this deed, or the revocation of the deed.
So let's say you named your daughter. You don't have to tell her that you're revoking it.
Right. You don't need to tell her. You don't need to get her to sign off on anything. Now, the public record, and that's the other problem too, or not the other problem, but the other thing to be aware of is all of these documents are public record, and now they're available electronically.
So if anyone did a title search, so if your daughter later looks and does a title search, she might see, well, you gave her the property and then you took it away.
Right. And what does that mean? Well, it might just mean that you did a better estate plan to get it to her,
Yeah.
But people might not understand that. But you can undo them. And if you're looking at it, you're saying, oh my God, I had no idea. Again, to go back around, if you did this on your own, it might not work because the recorder's office, it was notarized. It had something of a legal description on there, but they're not under any duty to check that for you. They're not under any duty to make sure your spouse signed off on it. That is not their problem.
Right. So going back to what you said earlier is the recorder's office could take your deed and record it, but that doesn't mean that the deed does anything.
Right. I mean, really, it drives the point home. And the thing with real estate, it makes up a lot of wealth for people. It's a significant asset.
It's usually the main asset.
Yeah. And it's public. These are recorded documents and there's insurance. And so we get to see the problems that are always there with listing individuals as beneficiaries. We kind of get to see that play out a little bit more publicly, than we normally do. If this was an IRA, we see the same problems with IRAs and bank accounts and, all of these other things. It's just not as public.
I mean, if a beneficiary predeceases.
Right. And not as newsworthy. And maybe we don't see the court cases like we do with real estate. But it drives this point home of you don't know what you don't know. And just because you found a form and just because you read an article and just because your neighbor did and it worked out doesn't mean that that's a good strategy for you. You have no strategy when you're doing it on your own. You don't have a strategy when you're doing forms. You are piecemealing this together, throwing darts at the wall and crossing your fingers and praying. And, sometimes stuff like that works out and a lot of times it doesn't.
Yeah. I mean, at the end of the day, it's a tool. It's a tool if used by the right person.
It's a tool. It's not a strategy. It's a tool that can be part of a good strategy. And so, if you're listening to this and you're thinking, I don't know, then you really need to take a step back and ask yourself, how important is it for me to make things easier for my loved ones? How important is this to me? And if it's not important enough to pay someone to do it right, then you got to ask yourself again, how important is this to me? And how seriously am I going to take this? And if you actually want to make things easier for people, then you should meet with an attorney, a knowledgeable estate planning attorney, to come up with that strategy, to get the right documents and done correctly to get that lined up.
Okay. All right. Well, thank you, Jen. This has been quite an informative episode. I appreciate you coming on because transfer on death deeds were new to me as well. So I learned a lot too.
Thanks so much for having me on. I mean, I can't emphasize enough that marriage of like a good strategy, good documents, good follow-up to make sure your assets do have the right beneficiary designations and all that good stuff. I mean, putting all those things together, that's what makes the results that people are looking for, where it is actually easy.
Great. Thank you very much. Thanks to Jen Gumbel for breaking down the world of Ladybird deeds, the good, the bad, and everything in between. Jen brings a rare mix of real-world experience as a Minnesota attorney and practical tools through her work as the founder of Organized Afterlife. Check out the show notes for ways to connect with her and learn more. This is Death Readiness, real, messy, and yours to own. I'm Jill Mastriani, and I'm here to help you sort through it, especially when you don't know where to start.
Hi, I'm April, Jill's daughter. Thanks for listening to the Death Readiness Podcast. While my mom is an attorney, she's not your attorney. The Death Readiness Podcast is for educational and entertainment purposes only. It does not provide legal advice. For legal guidance tailored to your unique situation, consult with a licensed attorney in your state. To learn more about the services my mom offers, visit deathreadiness.com.